Friends, thank you for being here today. What if I told you that on February 12th, 2026, the Environmental Protection Agency announced that carbon dioxide and 5 other greenhouse gases are no longer considered dangerous to human health and welfare, overturning 17 years of settled science and legal precedent in what Administrator Lee Zeldin called the largest deregulatory action in American history? And what if I told you that this decision represents not just an attack on climate policy, but a fundamental challenge to the constitutional principle that executive agencies must follow Supreme Court mandates and scientific evidence rather than political ideology? The EPA's rescission of the endangerment finding eliminates the legal foundation that has governed federal climate policy since 2009. This finding, established during the Obama administration, determined that greenhouse gas emissions pose a threat to current and future generations and therefore must be regulated under the Clean Air Act. The Trump administration His decision to reverse this determination strips the federal government of its authority to limit emissions from vehicles, power plants, and industrial facilities, while claiming to save American taxpayers $1.3 trillion. The constitutional implications of this action extend far beyond environmental policy. The endangerment finding was not a political decision, but a response to a direct mandate from the Supreme Court in the 2007 case Massachusetts versus EPA. In that landmark ruling, the court held that greenhouse gases qualify as air pollutants under the Clean Air Act, and that EPA must regulate them if they endanger public health and welfare. The Trump administration's rescission represents an unprecedented attempt by the executive branch to ignore a Supreme Court directive by simply declaring that the scientific basis for that directive no longer exists. The timing of this action reveals the administration as understanding that it faces immediate legal challenges that could reach the Supreme Court before Trump leaves office. By rushing to finalize the rescission, the administration ensures that Trump's Justice Department lawyers will defend the action before the High Court rather than allowing a future Democratic administration to abandon the defense. This strategic calculation demonstrates that the administration views climate policy not as a matter of scientific evidence or legal compliance, but as a political battle to be won through procedural manipulation. The scientific community's response has been swift and unequivocal. The National Academies of Sciences, Engineering, and Medicine released a statement reaffirming that the evidence supporting the original endangerment finding is beyond scientific dispute and has only grown stronger since 2009. Climate scientists note that the 3 hottest years in human history have occurred since 2024, with unprecedented extreme weather events causing billions in damage across the United States. The administration This claim that greenhouse gases do not endanger public health contradicts observable reality and settled scientific consensus. The immediate practical consequences affect every aspect of American energy and transportation policy. The EPA simultaneously announced the elimination of all greenhouse gas emission standards for vehicles produced between 2012 and 2027, arguing that the agency no longer has legal authority to impose such requirements. This action affects every car, truck, and motorcycle sold in America, immediately reducing fuel efficiency standards that have saved consumers billions of dollars in gasoline costs while reducing emissions. The automotive industry's response reveals the economic disruption caused by regulatory uncertainty. Major manufacturers had invested hundreds of billions of dollars in electric vehicle development and fuel-efficient technologies based on federal emissions standards that have now been eliminated retroactively. Ford and General Motors immediately announced reviews of their electric vehicle strategies, while Tesla's stock price fluctuated as investors tried to assess the impact of removing federal support for electric transportation. State governments have begun mobilizing legal challenges that will create a patchwork of conflicting regulations across the country. California Governor Gavin Newsom announced immediate plans to sue the federal government, arguing that the rescission violates the Clean Air Act and ignores scientific evidence. More than 20 states are expected to join California's lawsuit, creating a constitutional crisis where state governments defend federal environmental law against the federal government itself. The international implications undermine American leadership on climate change at a critical moment in global negotiations. The United States formally withdrew from the Paris Climate Accord for the second time just weeks before the endangerment finding rescission, signaling complete abandonment of international climate cooperation. Allied nations that had coordinated climate policies with American standards now face the choice of maintaining their own emission reduction commitments or following the United States toward climate policy abdication. The legal foundations of the rescission rest on controversial interpretations of Supreme Court precedent that legal experts consider legally frivolous. The Trump EPA argues that recent Supreme Court decisions limiting federal agency authority provide justification for ignoring the Massachusetts versus EPA mandate. However, constitutional scholars note that those decisions require agencies to have clear congressional authorization for major regulatory actions, not permission to ignore direct Supreme Court orders. The administration's economic arguments for the rescission rely on inflated cost estimates and ignore documented benefits of emission reductions. The claimed $1.3 trillion in savings assumes that compliance costs would continue indefinitely without considering technological improvements that reduce costs over time. Independent economic analyses suggest the actual costs of maintaining emission standards would be significantly lower, while the health and environmental benefits of reduced emissions would provide net economic gains. The precedent established by this action threatens the entire structure of federal regulatory authority based on scientific evidence. If executive agencies can ignore Supreme Court mandates by declaring that scientific findings no longer apply, then no federal regulation based on expert analysis is secure from political interference. This principle would allow future administrations to eliminate food safety standards, pharmaceutical regulations, and workplace safety requirements by claiming scientific evidence has become outdated or politically inconvenient. Congressional Republicans have largely supported the EPA's action while acknowledging they lack votes to codify changes through legislation. House Speaker Mike Johnson praised the rescission as restoring American energy independence, while Senate Republicans noted the action would boost domestic fossil fuel production. However, several Republican legislators from states affected by recent climate disasters have expressed private concerns about eliminating all federal climate policies during increasing extreme weather. The coal industry's response demonstrates how the rescission serves narrow economic interests rather than broader public welfare. Coal company executives immediately announced plans to increase production and reverse planned plant closures, despite market forces making coal increasingly uneconomical compared to renewable energy sources. Interior Secretary Doug Burgum's declaration that CO2 was never a pollutant directly contradicts decades of atmospheric science while providing political justification for increased fossil fuel extraction. The legal challenges facing the rescission will unfold over months, creating regulatory uncertainty that undermines business planning and investment decisions. Companies that developed long-term strategies based on federal emission standards now face the possibility that those standards could be reinstated by future administrations or upheld by federal courts. This uncertainty discourages private investment needed for clean energy development and emission reduction technologies. Environmental justice communities bear the disproportionate burden of the rescission's health impacts. Low-income neighborhoods and communities of color already suffer higher rates of asthma and heart disease linked to air pollution. Eliminating emission standards will increase harmful pollutants in these communities while providing economic benefits primarily to wealthy fossil fuel shareholders. The administration's scientific justification relies on the disbanded Climate Working Group, whose report was rejected by dozens of independent scientists for containing fundamental errors. A federal judge ruled that the Department of Energy violated public records laws in creating this group. Yet EPA Administrator Lee Zeldin cited the discredited findings as support for rescission. The global economic implications extend beyond climate policy to American technological competitiveness. Countries that maintain strong emission standards and clean energy investments are developing technologies that will dominate future energy markets. By eliminating federal support for clean energy development, the United States risks falling behind in industries representing trillions in future economic opportunity. The rescission affects federal funding for climate research and monitoring systems that provide early warning of extreme weather events. Scientific agencies that track greenhouse gas concentrations and develop emission reduction technologies face budget cuts justified by arguing such research is unnecessary if greenhouse gases do not endanger public health. State attorneys general have begun coordinating legal strategies that could result in the Supreme Court reviewing both the original Massachusetts versus EPA decision and the Trump administration as authority to rescind scientific findings. This coordination represents an unusual situation where state governments defend federal law against federal agencies, highlighting the constitutional crisis created when executive agencies ignore judicial mandates. The administration's approach to climate science reflects a broader pattern of subordinating expert knowledge to political ideology across federal agencies. The same officials who question established climate science have also challenged public health guidance and intelligence assessments when those conclusions conflict with political preferences. This systematic rejection of expertise threatens evidence-based governance foundations. The international scientific community has responded with unprecedented statements defending climate research integrity against political interference. The Intergovernmental Panel on Climate Change reaffirmed that greenhouse gas emissions pose an unequivocal threat to human welfare, while major scientific organizations express concern about American abandonment of evidence-based climate policy. The domestic political consequences extend beyond environmental issues to fundamental questions about scientific integrity in government. When federal agencies reject established science for political convenience, they undermine public trust in all government expertise, from vaccine development to economic forecasting. This erosion weakens democratic governance by eliminating shared factual foundations for policy debate. The timeline for legal resolution creates additional uncertainty for businesses and state governments trying to plan for environmental compliance. Federal courts typically take months or years to resolve complex constitutional questions, while the rescission's practical effects begin immediately. This disconnect forces private actors to make billion-dollar investment decisions without knowing which environmental standards will ultimately apply. Friends, what we are witnessing extends far beyond environmental policy into fundamental questions about how democratic institutions balance scientific evidence, legal precedent, and political ideology. The EPA's endangerment finding rescission represents the systematic subordination of expert knowledge to partisan politics, creating a precedent where federal agencies can ignore Supreme Court directives by simply declaring that inconvenient scientific evidence no longer applies. The administration's argument that greenhouse gases do not endanger public health contradicts observable reality, settled scientific consensus, and direct Supreme Court mandate. This contradiction reveals an approach to governance where political objectives override constitutional obligations and empirical evidence. When federal agencies operate according to ideological preferences rather than legal requirements, the rule of law becomes subordinate to partisan politics. The international consequences of this action extend beyond climate change to fundamental questions about American institutional reliability. When the United States abandons scientific evidence and legal consistency in favor of political expedience, allied nations cannot trust American commitments on any issue requiring long-term cooperation and evidence-based policymaking. The ultimate test of American constitutional government will be whether the federal court system upholds the principle that executive agencies must follow Supreme Court mandates regardless of political preferences. If courts allow the Trump administration to ignore the Massachusetts versus EPA decision by rescinding scientific findings, then the separation of powers that defines constitutional democracy has been effectively eliminated.